How does enforcing a court order work in Massachusetts? Hi, I'm Bill Farias, founder of Farias Family Law, and we get this question all the time. There's a court order in place, one party is not following it, and the other party wants to do something about it. In Massachusetts, that's called a contempt. And so the way that it works is if a party wants an order from the court for the other party to do what they're supposed to do, then that person would file a contempt with the court. So we're going to talk about a few things here related to contempts. First of all, whether to file it and the timing. In order to have a viable contempt case, so for it to make sense for you to even file a contempt, there are a couple of things to keep in mind. First of all, you want to make sure that it's worth your time and worth the court's time. So, for example, if there is a parenting plan in place and a parent doesn't return the child exactly on time, one time, and it's an isolated incident, then you obviously don't want to go rushing into court to file a contempt. If it happens every once in a while, that's a little bit different. If it's happening regularly, then that's something you may want to proceed with. Same with the financial issues. If somebody is behind a few dollars on child support, it may not make sense to rush into court to file a contempt. You could be wasting your time, wasting the court's time. So it's important before you rush ahead and file a contempt to figure out whether it makes sense to file a contempt under these circumstances. Another consideration is that you have to make sure that it's a clear and unequivocal order. So in other words, you have to make sure that what the judgment reads or what the order says actually obligates the person to do exactly what you're thinking they should be doing. And so a lot of this is based on the language that's used. So you may read something and think that it obligates someone to do something particularly, but if you have an attorney or a legal professional read it, they may not have the same exact opinion. There may be some gray areas. And so you want to make sure that if there is an issue and you think that a contempt should be filed, that you first of all have a legal professional take a look at that language to make sure it's a viable contempt before you rush in and file. So this also falls under the category of should I file at all? And the other part of that is timing. Sometimes it makes sense to file right away. Sometimes it makes sense to send off a letter first or an email asking the other person to comply. You're going to want to show the court that you've made an effort to resolve the issue. And don't get me wrong, sometimes it's unavoidable. Sometimes you actually have to file the contempt. But the point of this is make sure that you check your boxes to make sure that you are proceeding with a viable contempt case and that you're doing it at the right time. Finally, the other issue that is worth discussing is legal fees. And so the way that it works is if the court finds that an individual is willfully violating a court order, the court has discretion to order that person to pay the filing party's attorney fees if that person incurred fees. So this is another issue that you want to make sure you get assessed before you jump in and spend a bunch of money on an attorney and think that you're going to get paid every cent that you dished out. Not so fast. If there is a willful violation, I would say that judges are more likely than not to order attorney fees. But first of all, you should work with an attorney or at least talk to an attorney before you hire them all in to figure out what the likelihood is that you will collect attorney fees. And the other part of this is that you may not collect the full amount. So judges have a lot of discretion on attorney fees, and sometimes they will order just part of what you paid your attorney. So now that you know the basics on what comes or what goes into an analysis of whether you should proceed with a contempt and the attorney's fees component of it, An actual contempt hearing is both parties arguing before the judge on that particular issue, and essentially the judge determining based on the language in the judgment and the order and what the parties did or did not do, whether there was a violation of the court order. The judge rarely makes a decision on the spot. Sometimes they do. Usually they'll take it under advisement and issue a decision by mail on both the issues of whether there was a violation of the court order in the first place and the person is guilty of contempt, and also the issue of attorney fees. If you have any other questions about enforcing a court order, contempts, feel free to call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.